Okay, can anybody hear me? Hello, hello. Test, test, test. All right. Can hear me? Good. Well, this is the afternoon session. A little bit late, but this morning someone wanted me to talk a little bit about the Uniform Commercial Code, and I never ever talk about the Uniform Commercial Code. I never use it. Let me put it that way. I never use it unless I'm being forced to. When you use the Uniform Commercial Code, you know, with the law, the words are everything. And when the Uniform Commercial Code is international law. So when you use those words, you're putting yourself in international law. A lot of times what will happen, and I've seen judges do this, under Title I, Section 1 of the U.S. Code, it says that incompos mentis is insane, and which means that if you're incompetent, then you're insane. And people that I've seen people do it, where they would use common law terms and use commercial terms, and the judge will look at them and say, I think you're nuts. You need to have your head examined. And the reason is that those two things cannot live together. In other words, there is no such thing as common law under the Uniform Commercial Code. Uniform Commercial Code recognizes that common law exists. And so when you, like without prejudice, when you sign without prejudice, you're basically saying there's no contract. And you're asserting common law rights. If you like, for example, what they do is they go in there and use common law terms about a ticket. The Constitution doesn't apply, or the Constitution says I have the right to travel and all that stuff. And then they'd say, and I got my birth certificate authenticated. Well, that was like major problem. You never ever do that. It brings you into admiralty. Exactly. Never talk about Uniform Commercial Code. The only thing I ever do, if you look at all my documents, I don't say one word about the Uniform Commercial Code. If you I see people all the time will sign documents without prejudice, and they're using it on like an affidavit. If you put without prejudice on an affidavit, then you just nullified the signature. If you when you use without prejudice, that means there's no contract. And so you never ever, I only use that when they're forcing me to sign something. And then when they force me to sign something, like if I'm in their jail and they want me to sign a plea bargain or something like that, that's when I use without prejudice. because then there's no contract. And I've done that, actually. I can show you plea bargains that I signed without prejudice. I just printed without prejudice. That's all I put there. I didn't sign anything. I just put without prejudice. Under Title I, Section 1, a signature is a mark. So, under Title I, Section 1, when you print without prejudice, they have to accept it. And what they're doing, I can tell you right now, is what they're doing is they're taking the money out of that Satanic trust account. When you sign something, you just gave them permission. So you just paid for your jail through your Satanic trust account by signing something. And if you put without prejudice there, well then there's no contract. You only put without prejudice when they're forcing you to sign something. I can't tell you how many times I see people in an affidavit or something and they'll put without prejudice by the signature. I've had judges actually tell me, your writings are unintelligible to me. Well, that's because I was putting without prejudice there. That meant that affidavit didn't mean anything. There's no affidavit. There's nothing. It doesn't mean anything. Yeah. I just put without prejudice. If they're forcing me to sign something and promise to appear, I just print without prejudice there. I don't sign it, I just print without prejudice. And they have to accept it. And it doesn't mean anything. When you put federal judge told a friend of mine back in the 90s that when you put without prejudice, there's no contract. And that's all you need to know. And so I never ever talk about the Uniform Commercial Code in any of my documents unless I never do. There's no need to talk about it. That's foreign. That's international law. If you talk about the Uniform Commercial Code, you're basically saying that you want to go into commercial law, okay? And so there are a bunch of pirates. So they'll go into commercial law. That's what they're doing. They're trying to drag you into commercial law. And so they'll drag you in there. They're doing that already. I never ever talk about the Uniform Commercial Code. Never. I just if I sign it, if I put without prejudice, I just print without prejudice. Or you can do under duress. I wouldn't put UD though. I'd put under duress. And or without prejudice. Or you could print non-assumpsit. I suppose that would be the same thing. But the bottom line is, though, is that you only do that when they're forcing you to do something. Otherwise, you don't do it. You don't talk about it. You don't bring it up. You keep your arguments in common law. No need to tell them. I don't do that birth certificate authentication garbage. I think that's, I think there's a lot of Jesuits that are out there that are spreading lies and disinformation. I don't know that it's lies. I think that they're just ignorant. It's certainly disinformation. So I never use it. You'll never see me use any of that stuff in any of my documents. This document here is, now that we've talked about that a little bit, I waited for a few people to show up. This one here is called, we were talking about it before lunch. It was a demand for an examining trial. And this one here is a Word file from one I actually filed. And this was at Colleyville. I don't know if in Texas I have a certificate of, let's say, it's from the Texas Secretary of State. It says that the state of Texas is a DBA owned by Deer Park Cash Cow LLC. And so I always put down Deer Park Cash Cow LLC, aka State of Texas. And I always put that down. And this is Colleyville. And this case went away, by the way. Haven't heard a peep out of them. And but this is basically Randy Kelton's document that I just modified a little bit. You know, demand for an examining trial. On 6th of February was arrested, issued it by officer, that's that cop who was purporting to act under authority of Collywell Military Police. Said citation number, okay. It's the duty of the magistrate, when given notice that a crime has been committed, to convene and examine in court under Texas Code of Criminal Procedure 2.10, which reads, and here's, again, we're talking Texas codes. And so this is applicable in Texas. You have to find something equal to this in your state. So then this is it's the duty of the magistrate to preserve the peace within his jurisdiction, to use all lawful means to issue process intended to aid in preventing and suppressing crime, to cause the arrest of offenders by the use of lawful means in order that they may be brought to punishment. It is the duty of a magistrate to preserve the peace by convening and examining considered by the legislature on passage of Texas Code of Criminal Procedure Article 2.11, which reads examining court. When the magistrate sits for the purpose of inquiring into a criminal accusation against any person, this is called an examining court. Defendant in error moves this court to convene an examining court as referenced above, and hold said examining court in accordance with Texas Code of Criminal Procedure, Chapter 16, and set bail if probable cause is found. Defendant in error demands that defendant in error be accorded an examining trial when defendant in error appears. Motion to dismiss. An examining trial is a threshold requirement, and there must be in the record a determination of probable cause as required by Texas Code of Criminal Procedure Article 1617, which reads as follows. Article 1617, after the examining trial has been had, the judge shall make an order committing the defendant to the jail of the proper county, discharging him or admitting him to bail, as the law and facts of the case may require. Failure of the judge to make and enter an order within 48 hours after the examining trial has been completed operates as a finding of no probable cause, and the accused shall be discharged. In other words, if they don't hold an examining trial, then there's been they don't have probable cause. When there's no filing of an order under Article 1617, defendant in error will have a right to a ruling of no probable cause on discharge case. Right to examining trial by statutory mandate. Magistrates and prosecutors in Texas are trained to believe that a citizen does not have the right to an examining trial on a misdemeanor. The consideration of a right to an examining trial is not relevant. The statutory duty of the police, prosecutors, and magistrates concerning examining trials does not hinge on the rights of the accused. The lack of a mandated right does not equate to a prohibition. So there's a lot of this stuff that you could use in any state. In Clark versus State, the court addressed the Texas Code of Criminal Procedure Article 16.1, which states as follows. 1601. When the accused has been brought before a magistrate for an examining trial, that officer shall proceed to examine into the truth of the accusation made, allowing the accused, however, sufficient time to procure counsel. In a proper case, the magistrate may appoint counsel to represent an accused in such examining trial only, to be compensated as otherwise provided in this code. The accused in a felony case shall have the right to an examining trial before an indictment in the county having jurisdiction of the offense. So in other words, before they bring an indictment, you're supposed to have an examining trial even before an indictment. Whether he be in custody or on bail, at which time the magistrate at the hearing shall determine the amount and sufficiency of bail, if a bailable case. If the accused has been transferred for criminal prosecution after a hearing under Section 5402 Family Code, the accused may be granted an examining trial at the discretion of the court. So that's under the Family Code, it's discretionary. The Clark Court opined as follows. We do not construe Article 1601 of the 1965 Code is guaranteed to an accused the right to an examining trial in a misdemeanor case, wherein it was held that under the 1925 Code there was no necessity for an examining trial in a misdemeanor case. Further, there is no showing that an appellant requested or was denied an examining trial. In point of fact, in 1925, as today, rather or not a person had a right to an examining trial is not relevant. The well-established law clearly commanded every person making an arrest of another to take that person directly to the nearest magistrate by the most direct route as opined by Heath versus Boyd as follows. And this is the Heath versus Boyd case. And that is actually, it's a Texas case, it looks like. Yeah, it's a Texas case. If Heath's arrest had been authorized by the statutes, his subsequent detention as pleaded proved would make a case of false arrest against Boyd. The undisputed facts are that after his arrest, Heath rode with the sheriff to the former's car, which he then entered and drove several miles to the courthouse, followed by Boyd. There he was detained in Boyd's office from 1 to 3 hours while Boyd was seeking advice by telephone as to what to do, in the face of a plain statutory command as to what must be done in all cases of arrest without warrant. Article 217, 1925 provides each case enumerated in this chapter, the person making the arrest shall immediately take the person arrested before the nearest magistrate where the arrest was made without an order. Substantially the same requirement appears in the Code of Criminal Procedure 1925. Presumably there was a magistrate in Mertzon, the county seat. Yet Boyd offers no reason why he did not take Heath before that official. Neither in his pleadings nor his testimony does he suggest that a magistrate was not reasonably available, although the arrest and detention all occurred between 8 o'clock in the morning and noon. If he had taken Heath to that official, he could have gotten the information and assistance he was seeking by telephone. He was under no obligation to seek advice or aid from Johnson. He was under a positive duty immediately to seek a magistrate. That such failure makes a case of false imprisonment as a matter of law is held by all authorities. And so in other words, he had to take him to a magistrate. Prosecutors have advised the police and lower courts that the grant of a right of an examining trial before indictment in felony cases somehow negated the duty of an officer to take the person arrested before a neutral and detached magistrate for an examining trial in misdemeanor cases. If it were to be construed that a magistrate could not hold an examining trial in a misdemeanor, there would be no mechanism for issuing arrest warrants, and thereby no way for a trial court to accrue jurisdiction. Warrants issued an examining trial. So a lot of this stuff can be used in any state, quite frankly. Warrants are issued by magistrates after determination of probable cause. There is no other mechanism other than for a trial court to issue a warrant but that can only occur when a trial court already has jurisdiction in the case. Without an examining court, there can be no jurisdiction, as there can be no probable cause order as required by Texas Code of Criminal Procedure 1617. The courts and prosecutors seem to have lost their way when it comes to examining trials. First, who are magistrates? According to the Texas Code of Criminal Procedure, magistrates are as follows. Each of the following, Article 2.09, it goes through who is a magistrate. Basically, any judge, also mayors are magistrates. any judge it lists them all. Justices of the peace and the mayors and recorders and the judges of municipal courts of incorporated towns, cities, and towns. So mayors are magistrates, which is interesting. I mean, I'm not going to go through and read all those because it lists all these counties and stuff. The duties of magistrates are clearly stipulated by Texas Code of Criminal Procedure 2.1, which reads, "It is the duty of every magistrate to preserve the peace within his jurisdiction by the use of all lawful means, to issue all process intended to aid in preventing and suppressing crime, to cause the arrest of offenders by the use of lawful means in order that they may be brought to punishment." What is an examining court? We will get to the Texas Code of Criminal Procedure Chapter 16 shortly, but for the moment let's address Article 2.11, which reads, this whole document's only 11 pages, and we're already on page 4, so this is not going to be that lengthy. When the magistrate sits for the purpose of inquiring into a criminal accusation against any person, this is called an examining court. Examining courts are held when someone has reason to believe that a crime has been committed. In order to meet the due process requirements of the federal Constitution, a freeman cannot be deprived of his liberty absent a determination of probable cause by a neutral magistrate. This provision has been in law since the signing of the Magna Carta, drafted by the Archbishop of Canterbury and agreed to by King John of England on 15th of June 1215. It's called due process, that's right. The right of an examining trial has been entrenched in law from that time forward. While the right has not changed, the common practice has totally circumvented well-established law. The right of arrest changed. In 1967, the Texas legislature made what appeared to be a minor change to Texas Code of Criminal Procedure. Prior to 1967, Article 1401 read, "Offense within view. A peace officer or other person may, without a warrant, arrest an offender when the offense is committed in his presence or within his view, if the offense is once classed as a felony or as an offense against the public peace." And in 67, the law was changed by the addition of paragraph B. A peace officer may arrest an offender without a warrant for an offense committed in his presence or within his view. This looks rather innocuous on its face, but coupled with Clark versus State decision, which was handed down a month before this change went into place, everything changed. Now a police officer could arrest a citizen for anything, no matter how minor. With the Clark decision, the officer could take the person directly to jail, where the person was then subjected to a prosecution without a determination of probable cause. Change not in para materia within corpus juris. The addition of paragraph B to Article 1401 puts A and B at odds with one another. Paragraph B is also at odds with Article 1403, which further stipulates the conditions in which an arrest can be made without a warrant. Authority of peace officers. Any peace officer may arrest without a warrant persons found in suspicious places under circumstances which reasonably show that such persons would have been guilty of some felony, violation of Title 9, Chapter 42 Penal Code, breach of the peace, or offense under Section 4902 Penal Code, or threaten or about to commit some offense against the law. Persons who are peace officers has probable cause to believe have committed an assault resulting in bodily harm to another person, and the peace officer has probable cause to believe that there is danger of further bodily injury to that person. Persons who the peace officer has probable cause to believe have committed an offense defined in Section 2507 Penal Code if the offense is not committed in the presence of the peace officer. Persons who the peace officer has probable cause to believe that committed an offense involving any family violence. See, the family violence is different. Anyways, persons who peace officers have probable cause to believe have prevented or interfered with an individual's ability to place a telephone call in an emergency. Yeah, that's interfering with a 911 call, actually, if the offense is not committed in the presence of the peace officer. If the person who makes a statement to a peace officer that would be admissible against the person under Article 3821 and establishes probable cause to believe the person has committed a felony. A peace officer shall arrest without a warrant a person. Okay, so this is quite lengthy. Clark overruled by Gerstein. While Clark versus State appears to do away with an examining trial in a misdemeanor, however, a 1967 case was rendered ineffective by the decision of federal courts in Gerstein versus Pugh, which reads in pertinent part as follows. Maximum protection of individual rights could be assured by requiring a magistrate's review of the factual justification prior to any arrest, but such a requirement would constitute an intolerable handicap for legitimate law enforcement. Thus, while the court has expressed a preference for the use of arrest warrants when feasible, it has never invalidated an arrest supported by probable cause solely because the officer failed to secure a warrant. Under this practical compromise, a policeman's on-the-scene assessment of probable cause provides legal justification for arresting a person suspected of crime, and for a brief period of detention to take the administrative steps incident to arrest. Once the suspect is in custody, however, the reasons that justify dispensing with the magistrate's neutral judgment evaporate. There no longer is any danger that the suspect will escape or commit further crimes while the police submit their evidence to a magistrate, and while the state's reasons for taking summary action subside, the suspect need for a neutral determination of probable cause increases significantly. The consequences of prolonged detention may be more serious than the interference occasioned by arrest. Pretrial confinement may imperil the suspect's job, interrupt his source of income, and impair his family relationships. Even pretrial release may be accompanied by burdensome conditions that affect a significant restraint of liberty. When the stakes are this high, the detached judgment of a neutral magistrate is essential if the Fourth Amendment is to furnish meaningful protection from unfounded interference with liberty. Accordingly, we hold that the Fourth Amendment requires judicial determination of probable cause as a prerequisite to extending restraint of liberty following arrest. So, in other words, that's the federal court that said that. Statutory and due process duty to take the magistrate, as shown above. When a freeman, male or female, is restricted at their liberty under force of law without regard to the rights of the person arrested, the arresting officer has a statutory duty to take the person arrested directly to the nearest for an examining trial by a neutral magistrate. Where a person has been arrested without a warrant or on a warrant of county issuance, the arresting officer is required to take the person directly to the nearest magistrate by the most direct route. In the instant case, the arresting officer had a duty to take the person arrested before the nearest magistrate or released under Article 14.06, or on a promise to appear before some magistrate at a time and place stipulated so that a proper examining trial can be held. Under Texas Code of Criminal Procedure and Transportation Code, a police officer may arrest a person without a warrant. Under the same provisions, the officer is required to bring the person before a magistrate. The court should take judicial notice that in no case is the arresting officer required to bring the person so arrested before a judge, but rather before one of the magistrates named under Texas Code of Criminal Procedure. And we already looked at this. Well, under Texas Code of Criminal Procedure, public notaries are not magistrates. I'm looking at some of the comments. Where's the remedy for arrest on a warrant issued out of being locked out of court and winning my right to travel case? You'd have to sue them. That's what you'd have to do. Okay, back to the demanding for examining trial. So this is where you can tell if there's been an examining trial. I have been in downtown Fort Worth, and I searched because I did it for Randy, because he wants to force the issue. I searched over 100 cases in downtown Fort Worth, and none of them had an examining trial. And because the reason is that how they certify the documents. The magistrate is then required so transmit the documents to the original court jurisdiction as follows. This is how you can tell. The magistrate before whom an examining trial has taken place, that's Article 17.3, upon a criminal accusation shall certify to all the proceedings had before him, as well as where he discharges, holds to bail or commits, and transmits them sealed up to the court before which the defendant may be tried, writing his name across the seals of the envelope. The voluntary statement of the defendant, the testimony, the bail bonds, and every other proceeding in the case shall be thus delivered to the clerk of the proper court without delay. And so none of them had any of that. Okay, so he's supposed to write across the seal of the envelope. This seems to be straightforward enough. The magistrate had jurisdiction to hold an examining court based upon the filing of a criminal accusation after an examining into the sufficiency of the allegations where probable cause, if found, jurisdiction is transferred to the trial court by way of Article 17.3. Absent the above, the defendant in error has a statutory right to a finding of no probable cause. And so that's the end of it. Defendant in error moves this court to dismiss this case for failure to convene an examining trial in accordance with the statutory mandate of the Texas Code of Criminal Procedure. And that's it. That's it. And that's on page 9. And this is an order that you prepare and an affidavit of service. And that's it. So I haven't seen any yet in Texas that had proper examining trials. No, not even felonies. What they do is they try and get you to plea bargain the thing. And so that's why I just put without prejudice. I haven't dealt with the misuse of a 911, and a lot of times what I'll do is, if the cops stop me, I'll dial 911, and they will. A lot of times they'll say you can't use your phone while I'm talking to you, and I'll say, are you going to interfere with a 911 call? Because that's a felony. Anyways. If it's misuse, I mean, that's pretty hard to, if you have a sincere belief that they're committing official oppression, and that's what they're doing in Texas. It's called official oppression. It's called impersonating a public servant. That's a Class 3 felony. It's official oppression is a Class A misdemeanor, and that's what they're doing. I've never had anyone complain about dialing 911 when the cops stop me on the side of the road. I will upload this document. I'll upload it to Google Docs, and I'll put a link to it at the bottom of this video. This morning I went and uploaded that video, or the video's already uploaded because it's live streamed, but I put links to a bunch of criminal complaints at the bottom of the video from this morning. So, and this one, I will put this document up there, but you can also get it off of Randy Kelton's website. It's trafficticket.website. Okay, you just go to trafficticket.website, and you can put in your information, the date, the time, the traffic ticket citation, and all that, and that website will populate this form and give it to you in a Word file. All you have to do is print it, and it'll be ready to go. I got these documents off of Randy Kelton's website. It's trafficticket.website. He's pretty sharp when it comes to this stuff. If you read that thing, I mean, he nails it. And you know, when I was reading it, it was kind of broken, and you got to sit there and read it through and have some time to think about it. But it's pretty good. But you can get it. I'll upload this document. It'll be links to it'll be below this video, and the next document that we're going to be talking about. The next one is called a challenge to jurisdiction. This is another one. These are the two documents that I file into any traffic case. I don't care what the ticket is for. If it's a traffic ticket from the cops, then this is what they get. And I just make a couple changes and make an original and 2 copies. I have to get it notarized and file it. And original goes to the court. A copy goes to the prosecutor. In Texas, you know, you just give the court an original and a copy, and the prosecutor will get his copy there. And then I have a copy for my records. And I attach it to criminal complaints. Their file stamp copy. I start making criminal complaints and start filing those into it. And all sorts of criminal complaints for perjury of oath, for treason, not treason, but I've actually thought about doing it for seditious conspiracy. Certainly piracy, war crimes, the criminal complaints we went through this morning, and we'll go through some more this afternoon after we get through this one. But and then we'll do some more tomorrow. I mean, I got boxes of criminal complaints that I send, I'll tell you, and you know, it's like, you know, you make it so they don't want to talk to you. They can find some other poor schmuck that's asleep at the wheel, you know. Anyways, so we'll go through this one. Again, I have a certificate of fact, I guess it is a certificate of fact from the Texas Secretary of State that says that state of Texas is a DBA owned by Deer Park Cash Cow. So a lot of times they bring an action in the name of state of Texas, and so I always, and it's always with these cops, it's city police, it's always state of Texas. So I automatically Deer Park Cash Cow LLC, aka state of Texas. And this is the document that I filed into that case. When they gave me a ticket, they stopped me and they gave me a ticket for a dirty license plate. They couldn't read it. I guarantee you, if they would have known that they could have read it, they probably wouldn't have stopped me. Anyways, now comes Glenn Winningham Fern, herein referred to as defendant in the above style case, and moves the court challenge to subject matter jurisdiction. This one's a little bit longer. It's 25 pages. The last couple pages is an order and all that stuff. So this one goes through a lot of the same of the stuff as the examining trial, but it also goes through some other stuff that just pokes holes in their case, and you know, that they don't have a leg to stand on. Anyways, defendant has been cited for a violation of Texas Transportation Code. Defendant will show the complaint filed against defendant as insufficient to invoke the subject matter jurisdiction of the court. Statement of the case. Defendant on 6th of February has issued traffic citation for the who was purporting to be acting under authority of Colleyville Military Police. Said citation contains citation number. It is clear intent of the Texas legislature that the Texas Transportation Code is a statutory scheme of limited enforcement. The question begs, who can enforce the Transportation Code? And so that's why we go into Section 701 of the Transportation Code. A county commissioner's court may appoint 5 sheriff's deputies to enforce Texas Transportation Code under the provisions of Transportation Code Section 7, which reads as follows. Except as provided by subsection C, acting in conjunction with the sheriff of the county, the commissioner's court of a county may employ not more than 5 regular deputies as county traffic officers. Except as provided by subsection C of the commissioner's court may employ not more than 2 additional deputies as county traffic officers to aid regular officers in special emergencies. The limitation on number of deputies may be employed under subsections A and B does not apply to a county with a population of more than 2 million. So, in other words, with the population of 2 million or more, they can, that's when they can use 7. Along with the limitation on number of officers authorized to enforce the Texas Transportation Code, there's a further restriction stipulated by Transportation Code, Section 701, which reads as follows. County traffic officer, see, they have all these requirements. Shall be a motorcycle rider when practical. Cooperate with the police department of each municipality in the county to enforce state traffic laws in that municipality and in the county. Enforce state laws that regulate the operation of motor vehicles on a highway, street, or alley. Remain on and patrol the highway at all times when performing the officer's duties. An officer may leave the highway only in pursuit of an offender the officer is unable to apprehend on the highway. So they can only leave the highway when they're in pursuit. and they have to be on a motorcycle. And what else? Oh, they have to be on county payroll. Remember, it says the county commissioners have to do it. Inasmuch as the original complaint in this case is the citation alleges a violation of Texas Transportation Code, and said code is a regulatory scheme limited enforcement authority. In order for the complaint to have the capacity to bring an actual controversy to this court, the citation must demonstrate that the complainant has standing to enforce the statutory scheme under which the complaint was made. In addition, Randy Kelton does a really good job on this, I'll tell you. In addition to the authority provided by Texas Transportation Code, the legislature has authorized the certification of certain officers to do Department of Safety inspections on commercial vehicles. Peace officers are certified by Texas Commission on Law Enforcement and authorized to be employed for the purpose of enforcing the penal laws of the state. Texas Administrative Code, Rule 4.13, authorizes the sheriff of a county to appoint 5 persons to be certified as police officers as follows. Okay, so an officer of the department may stop, enter, detain on a highway or on a port entry a motor vehicle is subject to Texas Transportation Code. Non-commissioned employee of the department that's trained and certified to enforce federal safety regulations. So they're talking about commercial vehicles and safety regulations. The general provisions of the Texas Transportation Code, Section 644.101, stipulates who can be certified to perform safety inspections under Texas Transportation Code. Certification of certain peace officers. The department shall establish procedures including training for the certification of municipal police officers, sheriffs, deputy sheriffs to enforce this chapter. A police officer of any of the following municipalities eligible to apply for certification under this section: a municipality with a population of 50,000 or more, a municipality with a population of 25,000 or more, any part of which is located in a county with a population of 500,000 or more, a municipality with a population of less than 25,000. So there's a bunch of them here anyway, so who can apply? A sheriff or deputy sheriff of a county bordering the United Mexican states or a county with a population of 1 million or more is eligible to apply for certification. A sheriff or deputy sheriff or any peace officer that does not attend continuing education courses on the enforcement of traffic and highway laws, on the use of radar equipment as prescribed, shall not enforce traffic and highway laws. Right? There you go. Shall not. A sheriff or deputy sheriff or any peace officer that does not attend continuing education courses on the enforcement of traffic and highway laws and on the use of radar equipment as prescribed shall not enforce traffic and highway laws. The department by rule shall establish reasonable fees sufficient to recover from a municipality or county the cost of certifying its peace officers under this section. So it's a lot of hassle. There is nothing in the record to show that arresting officers met the requirements of Texas Transportation Code 644.101. Admittedly, the instant case does not involve the stop for the purpose of the Department of Safety inspection. The citation was lawful on its face. Officers not authorized to enforce. The above referenced traffic stop was made under the allegation of a violation of Texas Transportation Code. Texas Transportation Code is a code of limited enforcement in that the code may only be enforced by members of the Department of Public Safety and certain officers who have been certified under Texas Transportation Code 644.101. Impersonating a public official. A municipal police officer can be certified by the above if the officer has been appointed by the sheriff of the county in accordance with the Texas Administrative Code, and then the municipal officer may only do a safety inspection. Even if the above requirements are met according to the Texas Administrative Code, the municipality would have to be entered into a memorandum of understanding with the Texas Department of Public Safety as follows. So now they have a memorandum of understanding they have to do. See, this is why they don't do it. And look at all the requirements of that memorandum of understanding. Okay, the officer by statute cannot be certified to enforce the Texas Transportation Code under provisions of Chapter 701, and there's no evidence before this court that the officer was certified under Section 644. Official oppression. The officer at the time of the Terry stop was acting under color pretense of official capacity in the term as is construed by Texas Penal Code, which reads as follows: official oppression. A public servant acting under color of his office, so now he's engaged in official oppression is what he's doing, okay? Impersonating a public servant. The officer at the time of the traffic stop lacked authority as a police officer and was thereby impersonating a public servant as contemplated by Texas Penal Code, which reads as follows. And Texas 3711, impersonating a public servant. Aggravated assault. So now I'm bringing up the fact that they've committed, impersonating a public servant is a Class 3 felony, and official oppression is a Class A misdemeanor, and aggravated assault is, I'm not sure which one that is. Oh, it's a felony. Felony of the second degree. Aggravated assault, a person commits an offense if the person commits an assault as defined in 2201 and the person causes bodily injury, uses, exhibits a deadly weapon during the commission of the assault, which he did that. An offense under this section is a felony of the second degree, except is a first degree if the actor used a deadly weapon and during the commission of the assault causes bodily injury, regardless of whether the offense is committed under the offense is committed by a public servant acting in color of a public servant's office or authority. Okay, he was, so that means it's a first degree felony. The actor was in a motor vehicle as defined by Texas Transportation Code. So if you read that, I mean, I don't want to read the whole thing right now, but it looks to me like it's a Class 1 felony. Demand to appear on and before the above citation at issue in this instant case alleges the a criminal of the Texas Transportation Code contains an option to affirm a promise to appear. An officer, upon making arrest of on-site offense, is authorized under certain circumstances to release the accused on a written promise to appear. Texas Code of Criminal Procedure authorizes such a release, which reads as follows. That's Article 1401, authorizes the release. Where a person is cited under Texas Transportation Code, the authority to release the person on a promise to appear is contained in Texas Transportation Code 543.003, which reads, notice to appear. However, the above stipulated a condition to release under Texas Transportation Code, which reads as follows: time of a place of appearance, specified time. The time specified must be at least 10 days before the date of after the date of the arrest, unless the person demands an earlier hearing. The place specified in the notice of appearance must be before a magistrate having jurisdiction of the offense. An examination of the traffic citation referenced above will show that it did not designate a time to appear before a magistrate. The importance of this requirement will become clear when the rest of the requirement is considered below. Right to examining trial. So now it goes through the stuff for the right to examining trial. He goes through all the same arguments. So we'll just skip over that because we just talked about it. So let's see. The ability of the police officer to arrest a person for any reason, then be relieved of the duty to explain his actions to a neutral magistrate, it has the effect of ushering in the worst police state the world has ever seen. The current conviction rate for all crimes across the board in the state of Texas is currently at 99.6%. Everybody makes a deal, and that is because the examining trial has been dispensed with, and anyone accused of a crime is subjected to a cruelly crafted criminal connivance engineered by the prosecutor in order to relieve him or her of the necessity to adjudicate all the cases on his or her desk. All they need to do is pressure the accused into a deal. Magistration. They made it up. If a person is arrested in Texas, they will not be taken directly to the nearest magistrate, as statutorily mandated by Article 1406, which reads as follows. Instead of an examining trial, the accused will be granted a magistration. Persons arrested in Texas are routinely taken to jail and then eventually brought before a judicial officer who will hold what is loosely called a magistration. As I type this into Microsoft Word, the word processor puts a red line under it as it does not recognize the term. Word does not recognize the term as prosecutors made it up. There is no such thing in Texas law as a magistration. The hearing that is held resembles the hearing authorized by Texas Code of Criminal Procedure, Article 1517. However, this type of hearing is only authorized when a person has been arrested on an existing warrant for an out-of-county offense. Where a person has been arrested without a warrant or on a warrant of a county issuance, the arresting officer is required to take that person directly to the nearest magistrate by the most direct route as stipulated by Heath versus Boyd, which reads in pertinent part. This is not a difficult concept. And then he goes through Clark versus... So he actually modifies that examining trial stuff a little bit. Statutory and due process as shown when a freeman is restricted of their liberty, examining trial required before jurisdiction arraignment hearings. There is a provision for a person to be summoned to an arraignment hearing. Such powers is included in Texas Code of Criminal Procedure 2801, which reads, and so a pretrial arraignment. The court will take notice of Section 1, Item 1, which allows the court to summon a person to an arraignment hearing. The problem this court has is contained in Texas Code of Criminal Procedure 2601, which reads, arraignment in all felony cases after indictment in all misdemeanor cases punishable by imprisonment there shall be an arraignment. The court has no power to summon a person to a hearing unless there have been motions and pleadings filed in the court. Even then there is nothing given the court jurisdiction absent a determination of probable cause under Texas Code of Criminal Procedure. See, it goes back to probable cause again. Article 1617 goes to jurisdiction. So some of the stuff we're already covered. The citation did not state a date and time and place to appear before a magistrate. It is common practice in Texas to order an accused under authority of the Texas Transportation Code to appear before a magistrate. The citation in question failed, however, to state a date at least 10 days from the date of arrest for the defendant to appear. The citation included an agreement on part of the defendant to appear on and before a certain date. Said stipulation is not in compliance with Section 543.006 Texas Transportation Code, which reads, the time specified to notice appear must be at least 10 days after the date of arrest unless the person demands an earlier hearing. The place specified in the notice to appear must be before a magistrate having so they have to stipulate the date and time. Date and time and place of appearance. The citation ordered the defendant to appear on and before a certain date to appear before a magistrate. However, it is the practice of municipal justice of peace courts to refuse to provide access to a magistrate for the purpose stipulating by Article 1406. Instead, the defendant is required to appear before a county clerk impersonating a magistrate or judge. For a county court clerk impersonating a magistrate, there's some question here as to which is no proper examining trial held in Chapter 16. The clerk simply orders the defendant to enter a plea or will, as a matter of policy, refuse to allow the defendant to come before the magistrate. It is the accusation and allegation of the defendant that it was the intent of the officer that what defendant be denied a proper examining trial and finding of probable cause which is necessary. That should be trial. Finding of probable cause was necessary in order to bestow jurisdiction on the court. Now comes the defendant in special appearance and challenges the subject matter jurisdiction of the court. The instant action was initiated by a traffic citation. Said citation of it is to be taken as a complaint is insufficient to invoke the subject matter jurisdiction of the court, as it does not conform to the requirements of the Texas Code of Criminal Procedure 45.19. Does not run in the name of the state. The complaint does not commence in the name and by the authority of the state of Texas, as specifically required by Texas Code of Criminal Procedure, Article 45.19, and it failed to allege an offense against a law of the state. The complaint merely informally alleges speeding. The said complaint does not allege that the accused has committed an offense against the law of the state as required by Texas Code of Criminal Procedure, which reads, must show the accused has committed an offense against the law of the state. Defendant is left to guess as to the specific statutory scheme under which the complaint has been made, and therefore cannot determine what the requisites of such an allegation are. Therefore, the complaint is insufficient on its face. Does not conclude as required. The above referenced complaint fails to meet the statutory requisites of a complaint as required by Texas R 45.19, which reads, must conclude with the words against the peace and dignity of the state, and if the offense charged an offense only against under a minute, it may conclude with the words contrary to said ordinance. Does not beg jurisdiction. The complaint does not allege jurisdiction. Allege that the offense was committed in a county as required by Texas Code of Criminal Procedure 45.19. Complaint filed in Justice Court must allege that the offense was committed in the county in which the complaint is made. Texas Transportation Court presumption. Inasmuch as the citation fails to state a law which sufficient specificity for defendant to make a positive determination as to the statutory scheme under which the defendant has been charged, the defendant is led to presume that the allegation indirectly refers to Transportation Code 502.045. If this presumption is correct, then the complaint is insufficient as it fails to state facts that is sufficient to show that the defendant is subject to the statutory scheme of the Texas Transportation Code. Challenge is timely. The instant filing is timely, for the subject matter jurisdiction is a threshold issue and cannot be waived and may be challenged at any time. Subject matter jurisdiction cannot be waived and may be raised at any point in the proceeding. Jurisdiction cannot be conferred by agreement. Jurisdiction cannot be waived, neither can it be stipulated to. Either the court has jurisdiction or it does not. Subject matter jurisdiction cannot be conferred by judicial admission. And here's a court citation. Once challenged, jurisdiction must be proven by the above defendant challenges the subject matter jurisdiction of this court. On filing of the complaint, jurisdiction is presumed. However, once jurisdiction is challenged, the presumption of jurisdiction is lost and must be proven before the court can reach the merits of the case. Complaint sufficient on its face. In the instant case, the state filed to affirmatively plead jurisdiction as the citation on which the case is based failed to show that the complainant had the legal capacity to invoke the subject matter jurisdiction of the court. The citation contains an allegation by informal jargon and does not allege a violation of a specific statute under a named statutory scheme. Therefore, the complaint is insufficient on its face to invoke the subject matter jurisdiction of the court. Citation failed to state sufficient facts. Although the complaint does not clearly stipulate the statutory scheme under which the allegation has been made, for the sake of argument, in this case, we can only construe that the complaint alleges a violation of Texas Transportation Code. If that is the case, the limited authority to enforce the Texas Transportation Code must be considered. Defendant alleges and has shown conclusively above that the arresting officer lacked authority to enforce the Transportation Code and therefore is unable to invoke the subject matter jurisdiction of this court. Court must prove jurisdiction. Jurisdiction in a matter between defendant and the court. If the court that has made a demand upon the defendant, and therefore it is the court that must prove up its authority to rule, make demands on defendant in the instant matter. And there's some court citations. Jurisdiction not within the discretion of the court. Defendant reminds this court that the matter, if jurisdiction is not a matter within the discretion of this court, the burden shifts to the court to prove jurisdiction. Jurisdiction cannot be waived. Principles of waiver, consent, and estoppel do not apply to jurisdictional issues. The actions of the litigants cannot vest a court with jurisdiction above the limitations provided by the Constitution and Congress. Jurisdiction is essential. This court may not proceed until such time as the issue of subject matter jurisdiction has been proven. A failure to do so would amount to a fundamental violation of the due course of the laws and subject of the judge in this court to potential personal liability. The officer in the instant case asserted or purported to assert authority that he did not have, in that the officer is not qualified to enforce the transportation code. The officer is, as complainant, failed to allege facts sufficient to show that the jurisdiction under which the said officer derived policing authority was authorized by the state of Texas to enforce the transportation code. Said officer also failed to show individual authority by demonstrating that the officer was properly authorized as contemplated by Texas Administrative Code, and in that the officer failed to demonstrate certification under the Texas Transportation Code. The officer also failed to show personal qualification by meeting the training requirements. Therefore, the officer lacked the legal capacity to bring a controversy to the court, and thereby lacked standing to invoke the subject matter jurisdiction of the court. Affiant demands an order declaring that the court is without jurisdiction, dismissing all allegations with prejudice. And that's it. And then there's the order. So, let's look at some of the comments. Well, that's a good question, eh? Did police physically? I bet you they didn't. Matter of fact, they probably didn't have the classes. That's why I say they're pirates. That's right. No contract, no verified claim, no jurisdiction, no court. That's right. Okay, so that's basically that document. I'll upload that document as well. But again, you can get it on Randy Kelton's website, trafficticket.website. And what you do, that website's designed that you fill out your particulars, and it'll populate the forms. It'll populate them for you. Either that, or you can just download the forms, and you'll have a little bit more stuff to fix, because it won't populate them. It'll ask you the name of the court, all that stuff. So Okay, so we went through this criminal complaint with Joe Tooley in the war crimes. So what I'm going to do I'm going to start going through some of these criminal complaints. Okay, this is one that's one of the cops that the Euless cops that arrested me. It was actually the supervisor. They called him out. And this one's actually pretty short. It's like 2 pages. It's filed into that lawsuit again. So, in the name and by the authority of the state of Texas, remember, Texas codes require that. As a direct descendant of the founders of the Constitution of the United States of America, as one of the posterity found in the preamble, by right of blood, I hereby declare, I have reason to believe and do believe that Edgar Hurtado, Euless Police Sergeant 357, engaged in official oppression in violation of Texas Penal Code 39.03, which is a Class A misdemeanor, because he assisted Timothy Graham to stop the demander for having a Republic of Texas plate on his automobile, as evidenced in the Euless Police Department narrative. The demandant dialed 911, demanded Tarrant County Sheriff to the scene. The call went to the Euless switchboard, and Graham's supervisors, Sergeant Hurtado and Collingwood, came to the scene as his accomplices, as evidenced by the police narrative, and the Tarrant County Sheriff refused to come to the scene. The demandant read to Graham, Hurtado, Collingwood parts of Texas Penal Code 3903, telling them they're engaged in official oppression. They're all required to know that Euless military police are not authorized to enforce the transportation code, as evidenced by the email from the Tarrant County Sheriff Public Information Officer. True copies of the police narrative and email from the Tarrant County Sheriff's Public Information Officer are attached here too, each of which are incorporated herein by reference in their entirety. And that's it, against the peace and dignity of the state. It's 2 pages. It's real short. Anybody have any questions on that? I don't do anything about other than accuse them of, because payment bond, bid bond, performance bonds are all denominated in Federal Reserve notes. And so therefore that's perjury of oath. So I never, if anything, I file criminal complaints against them for perjury of oath, because they bonded the case. I do all of that stuff. And if they force me to sign something, I just put without prejudice there. No problem. I'll sign it. I'll sign anything you want. Sign anything you want. I don't ever put without prejudice on documents that I create. Notice this one. I don't put any reservations on there. It's full liability I'm exposed to. That's the only way you can do something with power. Never put without prejudice or anything like that there. Never ever. This is one that I do against the lawyers. This one is called simulating a legal process. That's a Texas crime. This one I'm doing against the bar members. This is Ashley Durker's a partner, and Taylor Olson Adkins Serrala Elam LLP, which Wayne K. Olson's a founding partner that represents the city of Euless, and a bar member and deemed to know the law. I love going after the bar members because they're the ones that are hanging, they're the low-hanging fruit. They're the ones you can always find out who their chief counsel is, who their lawyer is. You just do a little bit of research online, you don't even have to get out of your chair. These bar member scum are just hanging there waiting for you. Ashley Durker knows that properly applying the facts to the law is not discretionary, and misapplying the facts to the law in a matter is an abuse of discretion and official oppression, which is a Class A misdemeanor. I have reason to believe and do believe that Ashley Durker is simulating a legal process in violation of Texas Penal Code 32.48. The person commits an offense if the person recklessly caused to be delivered to any other document that simulates a summons, complaint, judgment, or other court process with the intent to induce payment of a claim from another. Well, that's what they do, isn't it? In support of their criminal street gang. Combination means 3 or more persons who collaborate in carrying on criminal activities. Participants may not even know each other's identity. Membership in the combination may change from time to time. Conspiring to commit, an agreement to commit, conspiring, an agreement constituting conspiring to commit may be inferred from the acts of the parties. So that's easy. Because civil law, and Roman civil law are convertible phrases. Roman civil law convertible phrases mean the same system of jurisprudence, that rule of action which every particular nation, commonwealth, or city has established for itself, more particularly called municipal law. And there's a maxim of Roman law, let he who is willing to be deceived, and they lie and cheat and steal, engage in fraud and deception when they criminally convert your name into Glenn Winningham Fern in all black capital letters in my name, my case, which is a Roman cult, Sestake Trust. Yet still it was found difficult to set bounds to ecclesiastical ingenuity. That's the Roman cult, folks. For when they were driven out of all their former holds, they devised a new method of conveyance, to which the lands were granted not to themselves directly, but to nominal fees to the use of the religious houses, thus distinguishing between the possession and the use and receiving the actual profits, while the season of the lands remained in a nominal fee, who is held by the courts of equity, then under the direction of the clergy, that's the Roman cult, folks, to be bound in conscience to account to the sestike use of the rents and emoluments of the estate. That's taxes. And it is to these inventions that our practitioners are indebted for the introduction of uses and trusts, the foundation of modern conveyancing. And that's taken from Tomlin's Law Dictionary, 1835 edition, volume 2, under the definition of mort main. Under their code, and it's also under the Code of Law for the District of Columbia. Chapter 854, an act to establish the Code of Law for the District of Columbia, March 3rd, 1901, by the 56th Congress, second session, 31 Stat 1189, and it says that the word person shall be construed to apply to partnerships and corporations, legal estates in the sestike use, the legal estate to be in sestike use. That's at 31 Stat 1432. That DC code is like about 200 pages, and it's now called United States Code. And they presume you're dead. Chapter 3, 31 Stat 1230, presumption of death. And they lie and cheat and steal, engage in fraud and deception when they forge your signature onto a quasi-contract, which is based solely on the Roman cult sestike trust. Constructive quasi-contracts are based solely upon the legal fiction or fiction of law. So they assault you with their Roman cult sestike trusts, and then they can assault you with their quasi-contract, where they assault you with some of their so-called benefits. I've heard of people that will go in there and say, I resign as surety for the Roman cult sestike trust, and all of a sudden the case disappears. Where they assault you with some of their so-called benefits. A quasi-contractual action presupposes acceptance and retention of a benefit by one party with full apprehension of the appreciation of the facts under circumstances making it inequitable for him to retain the benefit without payment of its reasonable value. Inequitable, okay? Equity. It's all about equity. Remember, under martial law, equity can do anything at once. Under common law, equity has to follow common law. But when they have martial law, this supersedes and replaces common law. A martial law can do anything at once. It becomes satanic. In doing this, I shall have occasion to, incidentally, to evince how true it is that states and governments were made for man, and at the same time as true it is that his creatures and servants at first deceived, next vilified, and at last oppressed their master and maker. A state like a merchant makes a contract, a dishonest state like a dishonest merchant willfully refuses to discharge it. And they lie and cheat and steal and engage in fraud and deception with their fake color of law warrant called a capias, which is a debt instrument. This is all their simulated legal process. And they're required to know that all of the so-called warrants were class 3 misdemeanors, which is punishable by fine only. And they're required to know that an arrest warrant may not be issued for a civil penalty. And they're required to know that a crime is defined as an offense punishable by confinement, which means a Class C misdemeanor is a civil matter. And they're required to know that the Ninth Circuit Court of Appeals, citing cases from the U.S. Supreme Court, 5th, 7th, 8th, and 9th Circuits, held that by definition, probable cause to arrest can only exist in relation to criminal conduct. Civil disputes cannot give rise to probable cause. And requires them to have jurisdiction under Texas Code of Criminal Procedure 43, Article 43.015. And they lie and cheat and steal and engage in fraud and deception, where the so-called judge is actually a bought and paid for a clerk masquerading as a judge. It's the accepted rule not only in state courts but in the federal courts as well, that when a judge is enforcing administrative law, they're described as mere extensions of the administrative agency for superior reviewing purposes, as a ministerial clerk for the agency. And bought and paid for clerks masquerading as judges are not competent to do anything judicial like issue warrants or orders. Ministerial officers are incompetent to receive grants of judicial power from the legislature. Their acts in attempting to exercise such powers are necessarily nullities. They routinely deny due process by failing to provide an examining trial. We talked about that, Article 16, 17. and the bought and paid for a clerk, Wayland for Grapevine, Murphy for Bedford, Britton for Euless, McCoy for Tarrant County, Del Carmen for Colleyville, Hutman for Azle, Dulong for Colleyville, Rogers for Fort Worth, Lane for Lakeworth, Bass for North Richland Hills, forges the demand and signature onto a bond under 17 Code of Federal Regulations 240.15C212, and are demanding fake money, military scrip, Federal Reserve notes, forced loans in the form of revenue for their criminal corporations, City of Grapevine, City of Bedford, City of Euless, County of Tarrant, City of Colleyville, City of Azle, City of Fort Worth, City of Lakeworth, City of North Richland Hills, and their police courts under their military dictatorship. And Graham is demanding military scrip, Federal Reserve notes in the form of revenue for the City of Euless and their police court, knowing they're demanding military scrip, Federal Reserve notes, and their warrant letters making threats for arrest, in which making threats of arrest demanding $282 or fake Federal Reserve notes for FMFR, failure to maintain financial responsibility, and $220 for the registration no plate. On each threat letter says you may simply pay by credit card, which means it is fake money. Federal Reserve notes, military scrip, forced loans, and they're required to know the Constitution of the United States is the supreme law of the land. Article 6, Clause 2. They're required to know that Article 1, Section 10, Clause 1 of the Constitution for the United States of America says that only gold or silver coin can be used in payment of a debt. No state shall enter into any treaty, alliance, or confederation, grant letters of marque, reprisal, coin money, emit bills of credit, make anything but gold or silver coin a tender in the payment of debts, pass any bill of attainder, ex post facto law, or law impairing the obligation of contracts, or grant any title of nobility. But the bought and paid for a clerk masquerading as a judge cannot ask for gold or silver coin because it is not in general circulation and has not been since 1964. And the bought and paid for a clerk masquerading as a judge has bonded the case by forwarding the demanding signature onto a quasi-contract under Title 17 Code of Federal Regulations, 2FR, Section 240.15C2-12. and associated regulations for revenue with Federal Reserve notes, which are intended to be used for the District of Columbia under the Gold Reserve Act of 1934. So they can hold a show trial and sell a demandant into slavery under the so-called 13th Amendment. Section 1, 13th Amendment didn't free the slaves, it made everybody slaves. Neither slavery nor involuntary servitude, except for punishment for a crime whereof the party shall have been duly convicted, shall exist in the United States or any place subject to their jurisdiction. By forcing the demandant to work for their criminal corporations for nothing, which is slavery, with their fines to collect Federal Reserve notes, military scrip, forced loans, fake money, he, the prisoner, has, as a consequence of his crime, not only forfeited his liberty, but all his personal rights except those which the law and its humanity affords him. He is for the time being a slave of the state. That's all part of their simulated legal procedure, which means they're all perjuring their oath of office to support and defend the supreme law of the land, is bringing District of Columbia codes not exceeding 10 miles square on the land of Texas in violation of Article 1, Section 8, Clause 17. To exercise exclusive jurisdiction in all cases whatever over such district not exceeding 10 miles square as may by cession of particular states and acceptance of Congress become the seat of government in the United States, and to exercise like authority over all places purchased by consent of the legislature of the state in which the same shall be for the erection of forts, magazines, arsenals, dockyards, and other needful buildings. Article 1, Section 8, Clause 17. And they are all required to know that Congress ratified the International Covenant on Civil and Political Rights as Treaty 95-20. Therefore, it is the supreme law of the land. This Constitution and the laws of the United States shall be made in pursuance thereof, and all treaties made or which shall be made under the authority of the United States shall be the supreme law of the land, and the judges in every state shall be bound thereby. Anything in the constitutional laws of any state to the contrary notwithstanding. And they're all required to know that the International Covenant on Civil and Political Rights Article 1 says all people have the right to self-determination. By virtue of that right, they freely determine their political status. Therefore, the demandant is the one who decides who he is, not some hired thug hired by international criminal corporations like the city of Euless, or not some bought and paid for a clerk masquerading as a judge. Britain, not their bar member ringleaders, Stacey White, Wayne K. Olson, and any of the and all of the have ceased to represent the government. But their first order of business is always to get rid of their pesky little common law problem by orchestrating some sort of emergency, because martial law is the rule of necessity and emergency under ex parte Milligan. So they can impose their military dictatorship as found in the causes and necessities for taking up arms. Statutes have been passed extending the courts of admiralty and vice admiralty far beyond their ancient limits for depriving us of the accustomed and estimable privilege of trial by jury in cases affecting both life and property, to supersede the course of common law and instead thereof to publish and order the use and exercise of the law martial. So that's where it says it, right? You cannot have international law and common law at the same time. Law martial is private international law. Cannot have private international law and common law at the same time. The Uniform Commercial Code is private international law. Because at common law, they'd all get their necks stretched at the end of a common law rope. Deuteronomy 24:7, if a man be found stealing any of his brethren or the children of Israel, or maketh merchandise of him, or selleth him, then that thief shall die. Thou shalt put evil away from among you. They are all required to know that no officer is authorized to enforce the transportation code, and their military police officers under instructions from their military chief and police, Mike Brown, and their bar member handlers, Stacey White and Wayne K. Olson, stop the demand for transportation of code offenses like having a Republic of Texas plate on an automobile, expired registration, or speeding, and their military police are not authorized to enforce the Texas Transportation Code, as evidenced by the email from the Tarrant County Sheriff's Public Information Officer. True copies of the threat letters and email are attached here to all of each of which are incorporated herein by reference in their entirety. And the demandant dialed 911 and the call went to the switchboard as intended by Wayne K. Olson, and the demandant demanded the Tarrant County Sheriff come to the scene, and they refused to get the Tarrant County Sheriff as intended by Wayne K. Olson, and they dragged the demandant into their torture chamber jail, where they engaged in torture with their forced fingerprinting, forced feeding poisons, and forced identification, and aggravated kidnappings, aggravated assaults, and their threats and their denials of due process, all of which is for revenue for their criminal corporations. The city of Colleyville, city of North Richland Hills, city of Grapevine, city of Lake Worth, city of Bedford, city of Euless, city of Angel, city of Fort Worth, and Deer Park Cash Cow masquerading as state of Texas against the peace and dignity of the state. I mean, you can. It's basically the same stuff in every one of them. This is simulating a legal process, but there's other ones too. There's other ones that are. How about suborning perjury? This is a good one. Chief of Police, this is a good one. So you have to think about these. I mean, I think about them. I've been thinking about adding seditious conspiracy, actually. I've been thinking really seriously about that, but I've been thinking about that for sure. Seditious conspiracy. Especially nowadays, with all of this stuff. I think we're at war. You know, given the biological warfare action that went on over the last couple of years, I think we are at war. I think that the military is starting to gear up for it. It's all very quiet right now, but I think that's that's coming. I think we are at war. So, so I've been thinking about, like, treason would be a really good one, because is basically giving aid and comfort to the enemy in a time of war. You know, I mean, you can certainly throw in those kinds of allegations against these kinds of people, because that's you know, something to consider. Any more questions? Well, first of all, I haven't talked to the IRS for probably about 10 years, and they don't want to talk to me. Although I have sent for transcripts, and I was thinking about filing amended returns and getting all my taxes back. But the guy that was helping me out with that had a stroke, and so he's not himself, and I hope he gets to be himself. But usually when things like that happen, they're kind of like on a downhill trend, you know what I mean? Anyways, yeah, you know, I guess we'll see. Oil and water, that's right. If you set it up right, it's like oil and water, and they just don't mix. I just file criminal complaints against them. If they won't let you file it into the case, file criminal complaints for that. Send it to the, I sent them to the FBI, I sent them to the state police, I sent them to the Provost Marshal General in Washington, D.C. If police officers are involved, I send it to, in Texas, I send it to the State Commission on Law Enforcement. And then what I do also is that's why I do all these bar members, because ultimately I'll file bar grievances, and I'll use these criminal complaints as evidence for the bar grievances. I'm curious to see what happens, because so far they've been blowing them all off, and I want to see what happens when I send them these criminal complaints. The next step would be to go to a judge and tell a judge that he's got to issue a warrant, and get them in there, see what happens, you know. Anyways, I'm in close. I talk to Randy Kelton all the time, and so I'll talk to Randy and network it with some other people. If I do file a criminal complaint into a court, I'm going to want to have lots of witnesses. Anyways, so this one is for suborning perjury. This is the chief of police. Again, it starts off in the same way: in the name and by the authority of the state of Texas. Now, I've got a pile of these things here. This is one that I've got. It's in a pile. I got two. I'm gonna see if you notice here. There's a court case right here. I'm gonna go file them into that case. That's a lawsuit that I brought, and actually, that case has been dismissed. But that's okay, because they didn't tell me they dismissed it, and it was like a year ago or so when they dismissed it. They're sneaking around behind me. They're playing some tricks on me, so that's okay, because I'm going to still file it. They'll take them. I've been filing them into this case, and then I'm going to go after them for hindering prosecution. I'll go after the judge, because I want to go after that son of a bitch anyways, so I'll go after the judge for hindering prosecution. I'll start filing judicial complaints and criminal complaints, and yeah, it ain't over. It's never over until you say it's over. Anyways, so in the name and by the authority of the state of Texas, as a direct descendant of the founders of the Constitution of the United States of America, and as one of the posterity found in the preamble, by right of blood, I hereby declare. I'm going to step away for a minute. I'll be back in a second. Okay, I'm back. By the way, before we get too carried away here, let's, I want to try and make a point of talking about my book. So, there we go. My book is now available, Trump, a True American Patriot or Not. Mike Blackwell co-authored it. Actually, he asked me to write the book, and it actually took me about, he's the publisher, it took me about 2 weeks because I just took a lawsuit and put it together, turned it into the book. And then he had to babysit me for about 6 months to get it ready to publish. And so, so he's the co-author, because he babysat me through that whole thing. And but it's mostly about 95% provable facts. There's very little in it that's my opinion, although there's a few things that are my opinion. Anyways, the back of the book is probably, it's something that I didn't write. The publisher wrote that, but I think it nails it really well as to what's in the book. And you can see it happening all around us right now. Anyway, so I'm going to read the back of the book. It says, "What truly matters is not which party controls our government, but whether our government is controlled by the people. At the center of this movement is a crucial conviction that a nation exists to serve its citizens." And this is a quote taken from Donald Trump in his inaugural 2016 inaugural address. So, and it goes on, "For too long, a small group of our nation's capital has reaped the rewards of government at the cost of its citizens. Washington flourished, but the insiders refused to share in its wealth. Politicians prospered, but allowed our jobs to leave and our factories to close. Not anymore." And then it goes on, this is not by Trump, this is by the people that wrote the book. In Trump, a True American Patriot or Not, Glenn Fern and Mike Blackwell reveal the depths of corruption, deceit, and manipulation infesting our political system for hundreds of years, regardless of political affiliation. Read the hard evidence that exposes how our elected officials sold Americans into slavery. Understand the Founding Fathers' true intent when they formed our Republican form of government. Discover the influence of the Satanic Roman cult on our politicians and political systems. Does Donald Trump want to transfer power back to we the people? In Trump, you will see the great battle that is upon us. And that is so true. And I think they nailed it there, I'll tell you. But, so I can't take credit for that, that's for sure. Anyways, you can order the book from Amazon.com or from my website, sovereigntyinternational.fyi. I prefer you order the book from my website. Amazon does not provide autographed books, and my website you'll get an autographed book. If you want something in particular, the autograph to say, you got to let me know. And so, do you want to know the origins of the deep state, who's behind it, where it came from, how it all got started? I mean, it goes back for hundreds of years. I go back, I only want to use stuff that I can prove, and that's where international treaties, court cases, law dictionary definitions, things like that, that's what I use to support everything I say. And there's stuff as back as far as 1213 that I have that I use to support what's going on in this book. Do you want to know why it's called the Trump administration? Do you want to know what an administration is? Do you want to know how Trump came to be president? Do you want to know who owns Congress? Yes, Congress is owned. Do you want to know why they're called law enforcement officers? Do you want to know how you have become a slave? Do you want to know what the root cause of the War of Independence was? Do you want to know why every president goes to visit the Pope on their first international trip? You know, and the biggest part of all of this is Federal Reserve notes, I'm telling you, because nothing's ever paid for. And so the absolute best you can do with the Federal Reserve note is quote-unquote discharge debt with limited liability. So you cannot pay, it's impossible to pay anything with the Federal Reserve note. So nothing's paid for as long as they can presume that you used Federal Reserve notes. That's why they have land property taxes, but you can actually have absolute title on your land. And my videos, I go through all of that. You can have absolute title on your land. You can have all of the things that our founders wanted us to have, but you got to get away from the Federal Reserve notes, or at least make it so they can't presume the Federal Reserve notes. You have to, that's how you become a slave, if you think about it, because you're using IOUs, they're bills of credit. Think about it, the Federal Reserve note is a bill of credit. It's printed by the private Federal Reserve Bank, and it's issued on the credit of the United States. So they're bills of credit. It's United States credit. It's like going to the store and buying something. When you give them Federal Reserve notes, you're giving them United States credit to pay for your groceries or for whatever. And so then if you think about it, who owns it? I mean, if you're using United States credit to pay for it, who owns it? The United States owns it. And that's why you have to pay the tax. That's right. And that's why you're a slave, because you don't own anything technically. Technically, anything, the Federal Reserve was set up under the insurance laws of the United States. And so therefore, anything purchased that's worthless insurance script. And anything purchased with worthless insurance script is the property of the issuer of the script. That's another thing. And so again, it's all on presumption, and you have to defeat their presumptions, and you have to know how to do that. And so, I mean, there's just so much that's going on, and people are just completely oblivious to it. And in reality, they're not after me, they're after you. I'm just in the way. And thank you, Donald Trump. So anyways, I'm going to see if there's any questions. Okay, so we'll go back to that suborning perjury by Michael Brown, who is the chief of police for Euless. As a direct descendant of the founders of the Constitution of the United States of America, in the name and by the authority of the state of Texas, as a direct descendant and founders of the Constitution of the United States of America, and as one of the posterity found in the preamble by the right of blood, I hereby declare, I have reason to believe and do believe that Michael Brown, Euless Chief of Police, is suborning perjury in violation of Title 18 United States Code, Section 1622, suborning perjury. Whoever procures another to commit any perjury is guilty of subornation of perjury, and shall be fined under this title or imprisoned not more than 5 years, or both. By screening all police officers, police department employees like Timothy Graham, Eduardo Hurtado, Collingwood for low intelligence, and then arming them and sending them out to enforce transportation code by stopping me for having a Republic of Texas plate on an automobile, and Brown is as evidenced is required to know they're not authorized to enforce the transportation code, as evidenced by the email from the Tarrant County Sheriff's Office, Public Information Officer, a true copy of the email, narrative, and citation which are attached here to, all of each of which are incorporated herein by reference in their entirety, thereby intending that they perjure their oaths against the peace and dignity of the state. And that's it. That's like a 2-pager. That's really short. And then with the attachments, it'll all be the same attachments. It's the same attachments I showed this morning in that other one. It's all the same. I just attach all the same stuff. So they're suborning perjury. That's the chief of police. I can accuse him of that. Here's another one, impersonating a public servant. That's a class 3 felony in Texas. And it's going to have all the same stuff. I'm going to file them all into that case, and then I'll send out I send the ones against the lawyers. I'll file bar grievances against them, and the ones against the judges, I'll file judicial complaints. In the name and by the authority of the state of Texas, as a direct descendant of the founders of the Constitution of the United States of America, as one of the posterity found in the preamble, by right of blood, I hereby declare, I have reason to believe and do believe that Edward Hurtado, alias Police Sergeant 357, engaged in impersonating a public servant in violation of Texas Penal Code 37.11. A person commits an offense if he impersonates a public servant with intent to induce number to submit to his pretended official authority or to rely on his pretended official acts. Knowingly purports to exercise any function of a public servant or a public office, including that of a judge and court, and the position or office through which he purports to exercise a function or a public servant or public office has no lawful existence under the constitutional laws of the state or of the United States. An offense under this section is a felony of the 3rd degree. Because he purported to be a traffic safety officer when he assisted Timothy Agreement to stop the demand for having a Republic of Texas plate on his automobile, as evidenced in the Euless Police Department narrative. The respondent dialed 911 and demanded Tarrant County Sheriff to the scene, and the call went to the Euless switchboard, and Graham's supervisors Hurtado and Collingwood came to the scene as his accomplices, and as evidenced by the police narrative, and the Tarrant County Sheriff refused to come to the scene. The respondent read Graham, Hurtado, and Collingwood parts of Texas Penal Code 3903, telling them they're engaged in official oppression. They're all required to know that Euless military police are not authorized to enforce the Texas Transportation Code, as evidenced by the email from the Tarrant County Sheriff's Public Information Officer. True copies of the police narrative and email and Tarrant County Sheriff's Public Information Officer are attached hereto, all of which are incorporated herein by reference in their entirety, against the peace and dignity of the state. And that's it. That's it. Those are short ones. Abuse of official capacity, another one. This is another one that's short. Oh, it's a little longer, I guess. Yep, that's okay. In the name and by the authority of the state of Texas, as a direct descendant of the founders of the Constitution of the United States of America, as one of the posterity found in the preamble, by right of blood, I hereby declare I have reason to believe and do believe that Edgar Hurtado, Euless Police Sergeant, engaged in abuse of official capacity in violation of Texas Penal Code 3902, which is a Class B misdemeanor, I think. Public servant commits an offense if with intent to obtain a benefit, with intent to harm or defraud another, he intentionally and knowingly misuses government property, services, personnel, or any other thing of value belonging to the government that has come into the public servant's custody or possession by virtue of public service officer employment. because he misused the Euless jail as police cruiser, radios, communications equipment, when he stopped the demandant for having a Republic of Texas plate on his automobile, as evidenced by the police department narrative. Graham failed to have probable cause to stop the demandant. Article 4 Amendment prohibits law enforcement officers from arresting citizens without probable cause. Arrest made without probable cause violates the 4th Amendment. Holding involuntary civil confinement is a massive curtailment of liberty, is tantamount to the infringement of being arrested, and can be made only upon probable cause. The test for police officers' sufficient basis for probable cause: did the officer have a sufficient basis to make a practical common sense decision that a fair probability of crime existed? Once the officer's actions fail to satisfy this test, that it may appear that no reasonably objective officer could have believed that probable cause existed to make an arrest. And the Ninth Circuit Court of Appeals, citing cases from the U.S. Supreme Court, 5th, 7th, 8th, and 9th Circuit, held that by definition probable cause to arrest can only exist in relation to criminal conduct. Civil disputes cannot give rise to probable cause. The so-called warrants that they came up with were in fact capious because they were Class C misdemeanors. An offense under this section is a Class C misdemeanor if the offenses for the actor's appearance is required as punishable by fine only. Conviction of a Class C misdemeanor does not impose any legal disability or disadvantage, and a judge guilty of a Class C misdemeanor shall be punished by fine only, not to exceed $500. And arrest warrants may not be issued for Class C misdemeanors if the owner of a motor vehicle fails to timely pay the amount of the civil penalty imposed against the owner. An arrest warrant may not be issued for the owner. The imposition of the civil penalty may not be recorded on the owner's driving record, and a Class C misdemeanor fails to be crime. A crime means a misdemeanor punishable by confinement or jail or a felony. And so in the Ninth Circuit Court of Appeals, citing cases from and we read that one already, and a traffic stop is an arrest. A motorist stopped by a traffic officer for a traffic offense would be considered arrested, even if the motorist was not specifically informed that he'd been arrested. Any restraint, however slight, upon another's liberty to come and go as one pleases constitutes an arrest. And a capious fails to be a warrant. On the roadside, the demandant dialed 911 and demanded the Tarrant County Sheriff to the scene several times, and the call went to the Euless switchboard, and Graham's supervisors, Hurtado and Collingwood, came to the scene as his accomplice, as evidenced by the police narrative, and the Tarrant County Sheriff refused to come to the scene, and the demandant read to Graham, Hurtado, and Collingwood parts of Texas Penal Code 3903, telling them they're engaged in official oppression. They're required to know that the Euless military police are not authorized to enforce the Texas Transportation Code, as evidenced by the email from the Tarrant County Sheriff Public Information Officer. True copies of the police narrative and the email and Tarrant County Sheriff Public Information Officer attached here to, all of each of which are incorporated herein by reference in their entirety, all of which are evidence of Graham's intent to abuse his official capacity. And this is actually Hurtado. They're all in on it. Against the peace and dignity of the state. So that's 4 pages. 4 pages. So it's pretty short. I keep them short. Gotta keep them short. The Word file for these criminal complaints are in the downloads. In the links to them are in the show notes of the morning video. The Word files for the afternoon session, for the challenge to jurisdiction and the demand for examining trial, those will be in the show notes for this video after it's done. I'll put them there. And yeah, there'll be the Word files. So you'll still have to build a case. I always get a police report. They always give you great evidence, okay? They're a bunch of hired thugs. They'll give you great evidence against them. And you just build a case. And send a in Texas, find out who the public information officer is and send an email. And ask them who, the names and titles of all of the traffic safety officers authorized to operate under Section 701 of the Texas Transportation Code, and see if they come back with anything. And even I would, as in that challenge to jurisdiction, it talks about Section 644 too. So I would probably, next time I do it, I'll probably ask for that one too, because those are safety officers. See if anybody are authorized under that too. But it's all a big hassle. I mean, they have to go through all of these requirements and crap, and so you know they're not going to do it. Because there's too many brain dead idiots out there that just mail in those checks, and so you know they're not going to do it. And so let's go through another one here. It's about a half hour. Let's see, which other one can we go through? Violating rights and immunities under color of law. That's a good one. Violating rights and immunities under color of law. That's a felony, federal felony. In the name and by the authority of the state of Texas, as a direct descendant of the founders of the Constitution of the United States of America, and as one of the posterity found in the preamble by right of blood, I hereby declare I have reason to believe and do believe that Edgardo Hurtado, Euless Police Sergeant number 357, engaged in violating my rights and immunities under color of law in violation of 18 U.S.C. 242. Whoever, under color of any statute, ordinance, regulation, custom, willfully subjects the habit of any state, territory, commonwealth, possession, or district to the deprivation of any rights, privileges, or immunities secured or protected by the constitutional laws of the United States shall be fined under this title or imprisoned not more than 1 year or both. So that's a felony. By collecting military scrip Federal Reserve notes in the form of revenue for the city of Euless and their police court, knowing they're demanding military scrip Federal Reserve notes, forced loans on their warrant letters, making threats of arrest. They're demanding $282 for FMFR, $222 for registration on each threat letter. Says you may simply pay by credit card, which means it's Federal Reserve notes, military scrip for forced loans. Hurtado is required to know the Constitution of the United States is the supreme law of the land under Article 6, Clause 2, and Hurtado is required to know that Article 1, Section 10, Clause 1 of the Constitution for the United States requires that only gold or silver coin be tendered in the payment of a debt. And Hurtado is required to know that Euless military police cannot ask for gold or silver coin because gold or silver coin is not in general circulation and have not been since 1964, and the Euless military police court may only ask for Federal Reserve notes because it is all that is in general circulation. And Hurtado is required to know that Britain and the city of Euless bonded this case under 17 Code of Federal Regulations, Section 240, 15C2-12 for revenue and regulations or for property of the United States under the supreme law of the land. This is Article 4, Section 3, Clause 2. The Congress shall have power to dispose of and make all needful rules and regulations respecting the territory or other properties belonging to the United States. So that means the city of Euless belongs to the United States, and nothing in this Constitution shall be construed to prejudice any claims of the United States or of any particular state, which means the city of Euless is property of the United States, and Federal Reserve notes are meant for use in the District of Columbia only under the Gold Reserve Act of 1934, which means that Hurtado is bringing District of Columbia codes not exceeding 10 square miles on the land of Texas in violation of Article 1, Section 8, Clause 17, to exercise exclusive legislation in all cases whatsoever under such district not exceeding 10 miles square as may by session of particular states and acceptance of Congress become the seat of government of the United States, and to exercise like authority. Okay, so that's Article 1, Section 8, Clause 17, and Hurtado is required to know that the demandant has a common law right to travel with his private property on the public highway. And here's a bunch of court citations that talk about that. And Hurtado is required to know the demandant has a right to use consumer goods instead of business equipment under their private international law that his District of Columbia court is using. And so then there's a bunch of stuff under the Uniform Commercial Code that I don't like talking about usually. But I'm telling them either way, I still have the right to travel. And under their edicts under martial law called Texas Constitution, consumer goods and household goods like the demandant's private conveyance are not subject to taxation. And that's Article 8, Section 1 of the Texas Constitution. And Hurtado is required to know that no warrant issued by the city or other municipal courts that the so-called warrant issued by other city or municipal courts is actually a capias, and a capias is not a warrant. And a capias is a dead instrument, which means it's a civil matter. And Hurtado is required to know that the Ninth Circuit Court of Appeals, citing cases from the U.S. Supreme Court, 5th, 6th, 7th, 8th, 9th, held that by definition probable cause to arrest can only exist in relation to criminal conduct. Civil disputes cannot give rise to probable cause. And Hurtado is required to know that no city in Tarrant County is authorized to enforce the Texas Transportation Code, as evidenced by the email from the Tarrant County Sheriff's Office, Public Information Officer. Therefore, none of the Transportation Code warrants issued by other cities in Tarrant County are valid, and all of them are color of law, and the defendant has a right to ignore anything that is color of law. And Black's Law Dictionary, color of law, the appearance or semblance without the substance of legal right, misuse of power possessed by virtue of state law, made possible only because wrongdoers clothed with authority of state is action taken under color of law. Because Timothy Graham stopped the demandant for having a Republic of Texas plate on his automobile as evidence in the Euless Police Department narrative. The demandant dialed 911 and demanded the Tarrant County Sheriff to the scene, and the call went to the Euless switchboard, and Hurtado's supervisors, actually that should say Graham's supervisors. Hurtado and Collingwood. That's what happens when you do the replace. Came to the scene as his accomplice, as evidenced by the police narrative, and the Tarrant County Sheriff refused to come to the scene, and the demandant read Hurtado. So this should be Graham. Hurtado and Collingwood. Parts of the Texas Penal Code telling them they're engaged in official oppression. They're all required to know that the U.S. military police are not authorized to enforce Texas Transportation Code, as evidenced by the email from the Tarrant County Sheriff Public Information Officer. True copies of the police narrative and the email from the Tarrant County Sheriff Public Information Officer are attached here to, all of which are incorporated herein by reference in their entirety, against the peace and dignity of the state. So that's pretty short and sweet. That's how many pages? 6. I want 6 pages. Violating rights and immunities under color of law. And then there's going to be conspiracy. This one's conspiracy. What you need to do is, in your local jurisdiction, is you need to, these are federal statutes, but the Texas statutes, you need to find comparable stuff in your local, like in Missouri or in Canada, or, and I know in Canada you got some really good stuff, because Canada has acceded to the Rome statute. The U.S. hasn't. Now the U.S. has passed some federal felonies designed to give remedy for the violations of war crimes and stuff like that, 18 U.S.C. 247, which is subjecting you to because of your religious beliefs, and so there's some good ones in the U.S. You got to look for them. You got to look around for them. But and the states, it just depends on the state. Some states are better than others. Texas is actually pretty good. But other states are not so good. Anyways, this one is conspiracy to threaten, coerce, injure, intimidate in the free exercise of rights. In the name and by the authority of the state of Texas. This is going to be a short one too. In the name and by the authority of the state of Texas, as a direct descendant of the founders of the Constitution for the United States of America, as one of the posterity found in the preamble by right of blood, I hereby declare, I have reason to believe and do believe that Edgar Hurtado, U.S. Police Sergeant, engaged in conspiracy to threaten, coerce, intimidate, injure me in the free exercise of my common law right to travel on the public highway with my private property and my right to own consumer goods under the color of law in violation of 18 United States Code, Section 241, conspiracy against rights. If two or more persons conspire to injure, oppress, threaten, intimidate any person in any state, territory, commonwealth, possession, district, or in the free exercise or enjoyment of any right or privilege secured to him by the constitutional laws of the United States, or because of his having so exercised the same, if two or more persons go in disguise on the highway or premises of another with intent to prevent or hinder his free exercise or enjoyment of any right or privilege so secured, they shall be fined under this title or imprisoned not more than 10 years, or both. And if death results from the acts committed in violation of this section, or if such acts include kidnapping or an attempt to kidnap, which they did, aggravated sexual abuse or attempt to commit aggravated sexual abuse, or an attempt to kill, they shall be fined under this title or imprisoned for any term of years or for life or both, and may be sentenced to death. So that one's pretty serious. Because he and Timothy Graham stopped the demand for having a Republic of Texas plate under his on his automobile under instruction from U.S. Police Chief Mike Brown, as evidenced by the U.S. Police Department narrative. Okay, so I mean, all of this, they give you great evidence. Get a police report. Anybody that doesn't get a police report is a brain dead idiot. They'll give you evidence against them. I mean, it's great. It's great evidence. The respondent dialed 911, demanded the Tarrant County Sheriff to the scene, and the call went to the U.S. switchboard and Graham's supervisors, Hurtado and Collingwood. So you dial 911, that's recorded, okay? That's all evidence. Came to the scene as his accomplices and co-conspirators, as evidenced by the police narrative, and the Tarrant County Sheriff refused to come to the scene. See, I'm going to go after the Tarrant County Sheriff next. I bet you I get his ass removed. The respondent read to Graham, Hurtado, Collingwood parts of Texas Penal Code 3903, telling them they're engaged in official oppression. They're all required to know that U.S. military police are not authorized to enforce Texas Transportation Code, as evidenced by the email from the Tarrant County Sheriff Public Information Officer. True copies of the police narrative and the email from the Tarrant County Sheriff Public Information Officer are attached here too, all of which are incorporated herein by reference in their entirety against the peace and dignity of the state. And that's it. It's a two-pager. And this is like kick butt. And we're going to be going through some more tomorrow. And I also want to go through. I haven't. I want to go through those ones that I did. Remember, we talked about them earlier against the Texas University of Texas. Okay, that cancer center, MD Anderson Cancer Center in Houston, Texas. I want to go through those because those ones, every case is going to be a little bit different. You have to modify them for each case, and so you have to do some research. And once you make one of them, then the rest of them are just about cookie cutters. Okay, what you do is you get your research, you find out who's involved, and then you collect your evidence, what the codes say, what they're required to do, and then it's just you make one up, and then the rest of them are just cookie cutters. You just copy and paste, eh? and you just one at a time. I'd really like to get a lot of people doing this. I'm telling you, we can really get them, start forcing them to abide by the Constitution, and the lawyers are the low-hanging fruit. The lawyers are the ones that are telling them to do this stuff, and they're the ones that we need to go after. But so, does anybody have any questions? The breach of the law occurring when the officer initiates a stop with the emergency lights. They're emergencies. Think about it. Okay, if it's a traffic stop and you know that he doesn't have authority to stop you for a transportation code offense, okay, where's the emergency? Okay, and so then he's going to tell you, we're investigating you. Well, then under the Fifth Amendment, you don't have to give evidence against yourself, okay? And if he's stopping you for a traffic stop, that's revenue, okay? He wants Federal Reserve notes, okay? So then, where's the emergency? Revenue. Since when is revenue an emergency? Think about it. And so, I mean, it's you just get them one way or the other. It's as soon as Federal Reserve notes get involved, then that's perjury of oath, because Federal Reserve notes are meant for the District of Columbia only, and so now you got them for a violation of Article 1, Section 8, Clause 17. They're bringing District of Columbia territory codes on the land of Texas. That's perjury of oath. It's emergency lights is where's the emergency? Okay, where's the emergency? If the revenue is not an emergency, okay, I don't know if you're getting this or not. But revenue is not an emergency, and if they're stopping you because of revenue, then it's not an emergency, and they perjured their oath of office. But also, so you got to build a case against them. You got to build a case against them, and so you let them hang themselves. And so you get a police report. You just what I do is I just I go through the stuff about where's the emergency, and then when they tell me they're investigating me, then I might dial 911. We got some official oppression going on, or I might just argue back and forth with them. It's hard to say, but I think I'm gonna it's hard to remember all this stuff when they're stopping you and the lights are going and all this other shit, and so it's you forget sometimes. So where's the emergency? And then when they're signing anything, you remember it's Federal Reserve notes, okay? Always put without prejudice. Don't even put your signature. Just print there without prejudice. Whenever you sign anything, just print. Don't refuse anything, okay? If you refuse, then they just put down refused and it's signed. You signed it. So you can't refuse anything. You have to just put without prejudice, because then there's no contract. And that's where they get their money, because they get you. If you refuse, then they get paid. If you sign, they get paid, because whether you pay them or the Roman cult, they get it out of the Roman cult Sestake Trust. Either way, they get paid. So you can't. You have to put without prejudice. You gotta. The way that we put a stop to this stuff is put a stop to their money. That's the way you got to do it. So it's one thing at a time, and it's hard to remember it all when the time comes. You just have to. It's just I get stopped and I do it every time, and so I don't get stopped too much anymore though, because I file all these criminal complaints, and I know they're taking my name in vain, because when that cop stopped me and looked at my Republic of Texas ID cards, Glenn Fern, you're Glenn Fern. So anyways, anybody got any questions? It's about time to wrap it up, I think. It's almost 5 o'clock here, and so we're getting close to time to wrap it up. If anybody's got anything, now's the time. Anybody has any questions, now's the time. If not, we'll start tomorrow morning at 10 o'clock. I was trying to do a live stream on this on my web hosting, but they just do not have it together. I don't know what was wrong over there. But so YouTube works. I know YouTube it's worked in the past, and I know how to do it. And this other place was, they just didn't have it together. Anyway, so I'm doing it on YouTube. But if anybody has any questions, now's the time, because it's almost 5 o'clock. We're going to wrap it up. The only thing I can say is build a case and collect your evidence and file your criminal complaints and use your evidence as evidence. When they turn on their emergency lights, revenue is not an emergency. So if they're saying there's an emergency and it's not an emergency, then that's abuse of official capacity in Texas. They're misusing their government equipment that they're using, right? That's a misuse of it's abuse of official capacity, which is misusing the government equipment that they're using, which is a Class B misdemeanor, Class B or Class A misdemeanor. I'm not sure which, but it's like throwing mud against a wall. You never know what's going to stick, right? So you just throw it against them, and shit happens. It's throwing mud against a wall, and you never know what sticks. They never tell you. They'll never tell you. It's all excess of authority. They don't have authority for anything. They're a bunch of thieves and pirates. Well, if nobody's got anything else, I guess we'll wrap it up. We'll be back live again tomorrow morning at 10 o'clock. And why don't you use the hyphen glyph when you write in all caps? Well, the all caps is their Roman cult Sestake Trust. So that's not a place to use the hyphen glyph. If I put my name, I put Glenn Winningham, House of Fern, and so then there's a colon between Winningham and House of Fern, because at common law only my given names are talked about. The family name is I'm only putting that there for courtesy, and so that's why I put the colon. But so I don't know hyphen glyph. I'm not sure exactly what you're talking about. Well, misuse of 911 you said was in Missouri, so I don't know Missouri law, and so I'm not sure at all. I don't know the circumstances around it. Again, you need to know your codes. You need to read your codes. I would say read your codes. All of your codes, all of it, from one end to the other, and. Randy Kelton said to read them from one cover to cover twice to get an idea, and that's going to take some time. And I know that you don't have a lot of time now, because you said something about your hearing on May the 4th, which is 2 weeks away, and less than 2 weeks, and so you're going to be under the gun. And so I don't know what to say. You gotta read your local codes. All of this stuff is because somebody's read the local codes. Randy Kelton did some great documents, and I use Randy's documents, and then I talked to a lot of people, and then Catman gave me some great stuff too, and you know, so then there's my own research and theirs, and so it all helps. But the bottom line is that you got to read your local codes. You got to read your local codes, and what are the circumstances around, you know, how you got this charge of misuse of 911. Why are they saying you misused it? So anyways, Clearfield Doctrine does say it all, that's for sure. All right, well, I guess we're going to wrap it up. Thanks, everybody. Glad you like it, Al Johnson and Denton. That's not too far. You should come to our meetings sometimes. We have meetings every Tuesday in the DFW area. Every Tuesday we have meetings in the DFW area. That's not too far from Denton, so you're welcome to come. We have Congress. Republic of Texas holds Congress every second Saturday of every month in Keene, and go to republicoftexas.com, and there's an address. There'll be an address there on Republic of Texas. Oh no, TexasRepublic.com. TexasRepublic.com, and you'll see there'll be an address there where you can that'll tell you how to find where we hold Congress in Keene. Keene is by Alvarado, so it's not too far. Matter of fact, there's our vice president lives in Denton. Maybe you can hook up with him and catch a ride. If you want a private consultation, I take donations. I never tell anybody what the donation should be. I always tell you to consider how much of my time you're going to need and what you think my time is worth. engineerwin@yahoo.com is my contact information, and you can contact me there. My website is sovereigntyinternational.fyi, and all of these videos, or most of them, are linked on that under the free videos link. They'll be there. This video is going to be unlisted here in a couple minutes because it'll be available for my Patreons. Ultimately, I'll probably make it public, but initially I make it available only to my Patreons because they're giving me donations. And so I appreciate it. I want to give them something for their donations. So, anyways, have a good one. Thanks for everything. We'll be in touch. We'll see you guys tomorrow morning at 10 o'clock Eastern time. That's 10 o'clock Eastern time in the morning. 10 o'clock Eastern time is when I'll be starting tomorrow morning.